Hello? Oh, okay. Ah,
Here we go.
it was on mute. That's why. Ah, my goodness. That is hilarious.
All right.
Okay. All right, we're good to go now. Play from start. Great. Let me just send this link to everyone.
Mm-hmm.
There we go. Okay, good. We should be all fine. Now, let me get the guys in the room. And I'll introduce Hey guys, we're ready to start.
Hey.
Okay, here we go.
That's it.
This is the keyboard. You can change.
All right.
All right. So we'll just wait on the other two guys.
Yeah,
to come in,
sure.
And then we'll
Now,
just
where's a
switch
good
to
spot
going.
for me to sit?
If you want to
Matter.
sit down, you can sit.
Yeah, why don't I sit off to the side? I don't need to be in shot. But if you want to give me the keyboard, and I'll just use that to advance. Yeah, all good.
Fantastic.
Cool.
Let me just grab one.
Excellent. Borrow this one so I can put it down there. I don't think I'll need the script. I do about one of these a fortnight. I'll see how I go.
All right, so we're in the late stage of our cycle now,
Yeah.
but the other guys are at the very early stage of our cycle, so they'll definitely benefit from this as well. What we're going to do, this is Rob, he's an IP expert, and he's very kindly to come in and give you guys a brief overview of intellectual property for your startups. So we have 3 of the startups here, 4 and Andrea contacting.
Okay.
And the other 2, I'm not sure where they are, but hopefully they'll come.
No, you always lose a few.
Yeah, that's right. So I'll leave it over to you, Rob.
Yeah, sure.
And I'll be back afterwards and to meet with Anthony as well.
Yep.
So yeah, thanks guys, and I'll leave it to
Okay.
Rob.
Yeah. No, all good. Go do what you got to do. Okay. So all your startups sort of ICT related?
Yeah.
Okay, all right. I'll try and keep it with a ICT focus. Then I tend to do a bit of each. Yeah, yeah. Okay, but you know, tech rather than life sciences or content. Yeah. Okay. I guess. I mean, the reason why I do these is, or the reason why people ask me to do it at least, is because I'm the guy. I've acted for pretty much all of the formal venture capital funds in Sydney over the years. And when the day comes that you do want to apply for, you know, try and get formal VC, chances are either me or someone who looks pretty much exactly like me in terms of qualifications will be doing the due diligence to decide whether you get the money from a formal VC. So the idea is that it's useful having someone like me talk to you guys while you're at this stage to know how things should look. In terms of the content, what I've effectively done is put it in order of importance, and we'll go as far as we go. I don't know how much time set aside for this. I was thinking that it might be an hour, but if it gets to the stage where people would rather ask questions than listen to me go through the final bit, that's fine too, and everyone's welcome to have the slides. So I tend to start off with why IP matters at all. I mean, at the broader sense, I run into a lot of people with startups who can't answer the question, well, what's to stop anyone else from simply replicating what you're doing? And these days, pretty much the only answer to that question is an intellectual property right that you can rely on. And people will try to say, oh, but it's all a trade secret, or I'm just so much smarter than everybody else. But it tends not to work. The fact is, once your product is out there, it's replicatable, and there's usually people who are capable of being faster and throwing more resources at a problem once they've had access to the smart ideas. So the purpose of IP is really just to put yourself in a position where you've got where your competitive advantage is sustainable, where you've got what you'd call a proprietary position in your technology, and sometimes that comes from patents, sometimes it comes from copyright. But there's a variety of sources of these legal rights. So I tend to start out though by saying that IP the end of the day. So all I really need to pull out from this slide is the fact that investors really focus on this stuff. Investors want to know that you've got some kind of strategy for protecting the IP in your product, not for its own sake, but for being able to tell them this is how my idea or my app or my software or my hardware can't just get replicated by somebody else as soon as it's out in the public domain. So what we use IP for, stopping others from copying, licensing it out. So if you come up with a great idea that's got one particular application that you're going to focus on, but it might be a platform that other people can use in other areas, then you might license out your software or your patent or whatever it is for a royalty. Again, making what you've got worth something to acquirers. And also, what I find is the startups that are able to say to the investors, here's our IP strategy, here's our IP portfolio, they tend to be the startups that have got the rest of their house in order as well, in terms of having the records, in terms of having confidentiality agreements with the people that they've spoken to or brought into the company. IP management's just part of good housekeeping in a startup. So, and this is really just a graphic that I use to talk about the different components of value in a startup company. Of course, most startup companies are virtual. You don't actually own any, the company doesn't own any physical objects that you can drop on your foot, other than possibly a bit of IT infrastructure, and that's about it. And so most of the value in a startup lies in the human capital, it lies in the expertise that you guys have got, the ideas that you've got, your hard work. But the trouble is, of course, you can be run over by a bus, and the value in the enterprise is then completely out the window if all the worth of the enterprise sits in your heads. So the point of IP management at the very broadest is to record all that good, smart stuff and turn it into systems and processes, even just to the point of writing code using best practice, so that somebody else can get into the code and service it, maintain it, and keep it going. And then some of that intellectual capital, when you've got all your ducks in a row, when you've got everything documented, some of that will become legally protectable intellectual property. Most of it won't, but the process itself is good business practice to follow. So that's sort of the intro about why IP matters. And this is really just the taxonomy of IP. So what kinds of IP are there? So at the very broadest, you've got patents which cover inventions. So patents cover how things work. So, if you've got your iPhone, there's probably 1,000 patented inventions in a single iPhone. Registered designs protect how things look, and we learned in the tablet wars that, for example, Apple claims a monopoly in the radius of the curvature of the corner of an iPad. They say, okay, this is the look that we claim a monopoly in, now with varying degrees of success, but it's just an illustration of the fact that registered designs protect how things look as opposed to how they operate. And trademarks, of course, so if you've got a funky brand for your startup, legally how you protect that is by registering it as a trademark. So those are the rights, the IP rights that you register with a government agency. So you've got to persuade some little man in a cardigan in Canberra to give you a patent for your invention. In terms of IP rights that exist without a registration process, so they happen automatically, copyright is the main one. Certainly if you're in the software game, copyright protects your software just the same as copyright protects a book or a play or a poem or something like that. I'll talk a bit about that and the limitations of it. Confidential information and know-how. A lot of startups rely very heavily on protecting their ideas and their products while they're in the development phase as confidential information or as trade secrets. That's all fine, but the problem is it's very hard to tell someone about your product and very hard to sell your product without telling someone what your product is. So, while you can submarine it while you're developing your product, you've got to have a strategy for protecting the IP after the product is out in the public domain and you're trying to tell as many people about it as possible. And goodwill and reputation is kind of just the unregistered flip side of trademarks. I'll talk a bit about patents initially. The idea behind a patent, and they've been around probably in the modern form, patents have been around for 200 or 300 years. The idea behind a patent is that if you make an inventive contribution to society, then you get a short-term monopoly over it to make your money out of it as a reward for making the invention, after which it's in the public domain and anyone can use it. And so that's settled down to a 20-year monopoly. And there's an interesting debate about the terms of patent monopolies and whether one size fits all in terms of different technologies. So arguably 20-year patents for pharmaceuticals are too short, whereas arguably 20-year patents for software are too long. But at the moment, it's 20 years around the world for everything. Patents don't protect abstract ideas. So, if I'm Einstein and I come up with E equals mc squared, then I can't get a patent for E equals mc squared, but I can get a patent for, the nuclear power station or the nuclear bomb, practical implementations of the idea that I've come up with, but a sort of a pure equation or algorithm is not in itself patentable. And the other thing is it's having a patent isn't a positive right to market something. So the fact that you've got a patent for your invention doesn't mean you can't infringe other people's patents. So in the IT world, I sometimes hear people say, oh, we're innovating so fast that we couldn't possibly be infringing other people's patents because we're way out in front of the pack. But the problem is that there's a lot of patents out there that are platform patents that cut across whole areas of technology. If I'm Gottlieb Daimler and I invent the car, I can get a patent for the car. And if Ferdinand Porsche comes along 6 months later with a Porsche 911, there might be 2,000 patentable inventions in the Porsche 911. Nevertheless, the 911 will still infringe Gottlieb Daimler's patent for the car. Then that actually happened with planes. The Wright brothers got a patent for the aeroplane, and they were collecting royalties for their patent term. Because obviously the Wright Flyer was a pretty crappy aeroplane. Nevertheless, for however many years it was after that, whatever the term was in those days, they were collecting royalties from the much better planes that followed after the Wright Flyer. Okay. So to patent something, it's got to be an invention. It can't be stuff that the law says you can't patent, and I'll talk a bit about what that includes. It's got to be new, and what that means is it can't be something that someone else has already done or someone else has already published. But it also means that it has to be new in that you haven't published it before. And that's why people talk about using non-disclosure agreements whenever you disclose the idea behind your startup. The idea is that a single non-confidential disclosure of an invention stops it from being patentable in future. There's a 1 year grace period in the US and in Australia, but it doesn't work anywhere else in the world. So in the game, we never actually advise people to rely on the grace period. So we encourage people, if you do think you might want to patent something, you want to file your patent application before you go public with it. And it has to involve an inventive step. So the idea is that it's got to be sufficiently better than, in colloquial terms, what's gone before, to deserve this 20-year monopoly as a reward for making some new contribution to society. That said, you would be amazed at what kind of tap can get patented. People who've been in academic research often tend to think that they need to come up with something that would be good enough to publish in a peer-reviewed journal to actually deserve a patent. But a lot of the patents that you see are for really quite tiny incremental innovations. Okay. So all the time you see patents granted for what's on the left, machines, processes, chemicals, drugs, that kind of thing. Where you get into the sort of controversies about what should be patented are the ones on the right-hand side. So methods of medical treatment. There are some places where you can't patent a method of medical treatment because the principle is that doctors shouldn't be looking over their shoulder worried about being sued for patent infringement while they're treating patients. But in Australia and the US, you can patent methods of medical treatment. Software in Europe and New Zealand, they've expressly amended their patent law to say that you can't patent software per se or as such, whatever that means. I think what that means is that if the software is just information in, information out, then it's unpatentable. But if you've got a piece of software that controls the way an industrial lathe works or something like that, then that software is patentable. So if you're in New Zealand and you're Fisher and Paykel and you've got a computer-controlled washing machine, then you can claim the software as part of the invention. But if it's like a spreadsheet where you put information in, you get an information result out, not patentable. In the US and in Australia, there's been a lot of controversy about the extent to which you can patent software. And I've actually got hot off the presses the latest patent that a federal court, that our federal court has found to be patentable subject matter. And essentially what these guys are claiming as patentable subject matter is doing questions and answers over the internet to determine whether someone meets an accreditation standard. But that's recently been found by the federal court to be patentable subject matter. So, don't let people tell you that you can't patent software. You certainly can, and you'd be amazed what you can get a patent for, particularly in Australia and the US. E-commerce and business methods, that don't actually involve the use of a computer. There was a period in the US where people were getting patents, like insurance companies were getting patents for insurance policies, and merchant banks were getting patents for investment strategies. But that's pretty much gone now. If it doesn't have a technological element, they're not really granting those patents anymore. There was a dude in Australia who ran the test case for business methods in Australia, and he was a lawyer who'd invented a way for debtors to hide assets from creditors so they didn't have to pay their debt. So you can imagine how that went. So the federal court sort of in Australia said, no, not going to give you patents for that kind of thing. There's also, of course, been arguments about patenting gene sequences. There's been a couple of government inquiries into that, and patents over higher animals. So pretty much everywhere you can get a patent for a cell line, as used in drug development, that kind of thing. But there are some jurisdictions where you can't patent, for example, the Onco mouse, which is a laboratory mouse that's genetically engineered to be more susceptible to getting cancer, and then they use that in clinical trials, preclinical trials. Okay, so that's sort of the basic nature of what a patent is and what you can get a patent for. How it works in terms of what you actually do when you want to get a patent. So step one is having a look on the patent databases, which are all the major countries now, their patent databases are online. And you can go on and see who's been patenting what in your area of interest. So IP landscape, first step, you just get on uspto.gov or any of the other patent sites. There's even now a Google patent site that aggregates all the data from different patent offices. So if you want to see who else is patenting stuff out there, have a look at what others have patented, and then decide whether you've got an invention that does meet the basic criteria. And this is what patent attorneys do for a living, as opposed to lawyers like me. How the timeline works is you can file a provisional patent application. It costs about $5,000 typically. But the good thing about that is that it then holds the position for at least holds the position for a year, and then you've got the option to file a multi-country application. It's called a PCT application, and that can cost you sort of 10 or 15 grand. But the point of using this process is that you actually get to 2.5 years, 30 months, before you have to go filing patent applications in all the individual countries where you want patents. So it's sort of like buying an option. You can file an application and hold it for a while.
What if you've already disclosed? How long do you have before can you get a provisional?
The grace period is 1 year, if you've already disclosed, and it only works in Australia and the US. But for a lot of you guys, Australia and the US is enough of a chunk of the world market that it's still very much worth giving it a crack. Yeah. And importantly, at 18 months after you first filed your provisional application, then the PCT that you filed afterwards gets published. So the world knows what you're doing, and it's all searchable online. And then, as I said, 2.5 years down the track, you file patent applications in individual countries, and then it can take 5 or 7 years from that first date before you actually get a granted patent. Now, interestingly, I've been a partner in a patent attorney firm, and I went in thinking, well, why don't people push harder? Why does it take 5 to 7 years? The answer is clients mostly ask that you stretch the process out for as long as possible, because they'd rather keep the competition guessing about whether they're going to get a patent granted, and keep the competition guessing about what the scope of the patent will be. So in some situations, having a pending patent application is actually more valuable than having a granted patent, especially if the patent's going to be a bit questionable. So the 5 to 7 years is actually a feature rather than a bug from the point of view of pretty much any client that I've ever spoken to about it. You do have copyright, of course, particularly if you're in the software game. And I've sometimes heard it said that you don't need to worry about patents if you're in the ICT world, because you've got copyright in your software. The issue with that is that copyright's only a protection against copying, whereas a patent's a protection that gives you the monopoly even if somebody else completely independently develops the same or a similar technology. So copyright stops someone from taking your software, having a look at it and going, yeah, okay, I'm going to replicate that. But copyright doesn't stop someone from looking at your app or whatever it is and going, oh, that's a great idea. I'm going to go and find a coder who's never actually seen the code of that other app. I'm going to say, hey coder, write me something that does this. That second piece of software written by the clean coder will not be a copyright infringement of the original app. So that's the limitation of copyright primarily. It doesn't protect the concept or the idea. It only protects the way that the code was specifically written to implement the idea. I don't need to say much more about copyright. I'll press on just because of time. Confidential information. I've probably said all I really need to say about this for practical purposes. But again, like copyright, it's not an absolute monopoly. Having something as a trade secret stops someone from taking your trade secret and going off and using it for their own benefit. But of course, it doesn't stop someone from independently developing the same idea because they thought of it themselves independently. And also, the limit on trade secret protection for anyone who actually wants to sell a product is that you can't sell a product without telling people about it. So I have seen ICT businesses that successfully use trade secret protection. But what they tend to be businesses that operate by running a process on a server that crunches numbers that are fed in by the clients, and there's an algorithm on the server that stays on the server and can't be reverse engineered from people punching in different data and analysing the results. So if you had a fantastic stock picking piece of software or something like that, you might be able to make money by keeping it as a trade secret, but only to the extent that it couldn't be reverse engineered eventually by people correlating the data and the output. Okay. Trademarks and brands, I won't say too much about it. Brands tend to be secondary for tech startups, but if you think about it, the Apple, of course, brand itself, I think its most recent valuation was $185 billion, just for the Apple brand. But if you think about, Dropbox or any of those, clearly, once your IT startup gets a bit of traction, the brand does actually become a tremendously valuable part of the business. So, you can have brand protection for words, logos, shapes. You can actually register a sound as a trademark. So if you've got particular notifications in your software and it becomes famous, or you want it to be proprietary to you, if it's highly distinctive, you can actually register that as a trademark. Technically, you can even register a smell as a trademark in Australia. It's got to be distinctive, so it can't just describe what it is that you're doing. But there's a bit of leeway around that. And if you're going to register a trademark, it is something that you can do online. But keep in mind that registering your trademark in Australia, for example, doesn't help you in the US. So if you are registering brands, you actually have to register them in all the markets where you want to protect it for it to be much use. Okay, so in terms of what do you want to do about IP in a startup company, the issue is really when you get to the point where you've got some money from, you've got a co-founder, and then you've got some money from friends and family, and you've got some money from angels who've just sort of had a quick look at it. But if you do get to the point where you need the sort of Series A, in Australia it's typically 2 to 5 mil, overseas it's more, they're going to want to do formal due diligence on you and make sure that they're satisfied that, as your business model scales up, it can be protected from just being replicated by others. And then when you do your exit, of course, you'll have, somebody who's probably US-based lawyers going over the whole business with a fine-tooth comb and, spending like hundreds of thousands of dollars checking everything. So the point is, at this very early stage, to do what you absolutely have to do to get your house in order, but try and do it efficiently and cheaply. I don't think I need to say much more about that. But yeah, the point is, I guess, avoiding creating issues that won't pass IP due diligence. And I've got a couple of those issues to talk about. So firstly, what are the key technologies? Are there IP rights that protect the key technologies, and do we think that's going to continue? Third one's important. Does the company actually own its IP? And this is one of those ones that tends to get looked at very closely because it's easy to check. You know, you can't necessarily tell whether something's patentable or whether it infringes any other patent on a quick look. But if I go into a startup and, for example, the code's been written by a contractor and the company can't show me an assignment of the copyright in the code from the contractor, then that's a big black mark right from the start, and you then get worried, what if there's other stuff they haven't done? So that's one of the sort of no-brainers, making sure that you can show that the company does own the IP. And then, is it contractually free to actually use the IP? So a lot of startups in Australia come out of universities, and so you look very closely at the assignments and the licenses of the IP out of the university to make sure that the startup's got all the rights that it needs to do what it's going to do. Then you look at any patent applications. Are they going to get up? And what scope of monopoly will they give? Will you be infringing any third-party IP rights? And then the general scope of IP management. So this slide and the slide before is kind of my absolute highest level checklist when I come in to look at a tech company for investors. Making sure that we've got ownership. An issue with startups is you tend to use a lot of contractors, and you might retain sort of Airtasker type contractors, Indian guys to cut code or whatever. Very important to have a bundle of legal assignments and legal confidentiality agreements with anyone who's provided services to the company. If you did take the technology out of the uni, assume that you're doing a PhD or an honours year and you want to keep going, and there's some IP the uni has that you need. It's all got to be properly documented. If you've gotten government funding, making sure that the funding conditions don't interfere with what you're going to do. So, for example, there have been historically some sources of government funding where the Commonwealth will say, okay, you can have this money, but if you're going to sell the IP out of Australia, we have to know about it and we can refuse consent. So, of course, the investors hate that. So if you are getting any kind of grant money, make sure you're fully aware what the conditions are. If you're developing IP in-house, make sure that you're thinking about, am I capturing the IP? Have I just invented a patentable invention? Can I show that we own copyright in this? If you're licensing it in, say from a university, how much am I paying? Am I able to use the technology in all the fields I need to? Is there any other IP further back that the uni might control that I need? If you do a collaboration, now, collaboration is really important. Now, if you're doing your development right, of course you should be talking to suppliers and customers and channel partners. Rule 1, non-disclosure agreements, but Rule 2, sometimes you'll get into really detailed discussions with potential, channel partners, resellers of your software or whatever, and you'll start to get into a co-development or a collaborative development kind of relationship where they'll be saying, well, hang on, have you thought about doing this? Why don't you do that? Or we think the market would really like it if you had this feature. The problem with that, of course, you can get to the point where you co-invent something and you're actually joint owners of the IP in that idea and that invention. And so if you are going to do a formal collaboration with a supplier or a university or a customer, just make sure that you get it legally documented and you work out who owns the IP. Don't sort of hype up. If you do have patents, don't sort of hype up what you've got. There's no such thing as a worldwide patent. If someone sees in an information memorandum or something, we have a worldwide patent, they'll run a mile because they'll know that you don't really know how the system works. It's easy to file an application, so startups will say, hey, we've filed an application, talking as if it's somehow certain that they'll get it granted, but often they aren't. And even if you've got a granted patent, keep in mind that it might not be valid if someone challenged its validity, if you ever tried to enforce it. The courts tend to find about a third of all patents that companies try to enforce, the courts find that they're invalid. They should never have been granted in the first place. So even if you get a patent granted, there's still that level of uncertainty. And it varies country to country, just to make it even more expensive. So in terms of IP management, we're getting towards the end now. The kind of relationships that you need to document properly. So employment contracts with anyone who's actually employed by your startup. If you've got contractors, making sure that there's IP assignments in the contracts that you use when you hire people to cut code or whatever. Recognise if you're in a collaboration, especially with suppliers and customers, make sure you document who owns the IP. If you are doing or sort of planning your R&D, and this is something you would talk about with a patent attorney if you did go down the patent path, quite often there's a particular line of inquiry you'll go down with R&D that isn't directly to develop your product, it's actually to broaden your patent rights. So the development process that you do to develop your product might actually be different from the development process that you do to develop your product and get a strong patent position. There might be extra development that you should do to strengthen the potential patent position that you might have. And patent attorneys, if they're any good, can help you with that. And then understanding the IP landscape, so knowing what your competitors have patented, because it's all available online for free. So, it really is a no-brainer to get on those websites and check out what others are doing. It's great competitive intelligence apart from anything else. So on my Zeit feed the other day, it just absolutely exploded because an Apple patent application had just been published, which talked about earbuds with a whole array of health sensors inside the earbuds. And so, obviously everyone looks at every Apple patent that publishes, creates an article from somewhere. But you can, if you've got specific competitors, you can actually track their patent publications as they come out. You can even set up alerts so that if someone who you consider kind of in your game but a couple of years ahead, you can actually get an alert whenever one of their patent applications gets published. So point of knowing the IP landscape, mainly for competitor intelligence, but also knowing what your potential business partners are doing. So you might think, well, this company's my logical acquirer, this company's my logical channel partner, this company's my logical reseller, so I'm going to track their filings as well, just to know what they're up to. If you're doing formal R&D, just some tips for planning your R&D. So make sure that you're thinking about IP as an issue when you plan your R&D. Make sure that you're pausing every now and then to think, well, have I come up with a patentable invention? Is that a copyright work? Should I make sure that I document when I wrote it, who wrote it, the fact that I got an assignment of the copyright? Consider how protectable new products are. If you might actually have options that involve making a product more protectable rather than less. Try and avoid infringing third-party IP rights as you're developing the product, rather than getting a nasty surprise when you launch. And also, if you are looking at the patent landscape, it'll occasionally throw up opportunities to license technology in. So you might find that somebody else is working on a technology that's useful to you and they've already gotten further down the path. And it might actually be a better idea to call them up and say, hey, can I use that technology and pay you for it, rather than, reinventing the wheel yourself. So this is just different ways in which you use IP, building a bundle of IP around your product so you can stop copying by others, putting roadblocks in competitors' paths. If the masterclass option for getting IP right is when you really are buggering up your competitors by putting roadblocks in their path. If you've got a strong IP position in your little bit, it really helps you if somebody else turns up and they've got IP rights that cut across you, because you can trade with the rights that you've developed. Building value for market perception. Basically, investors like to see that you've got an IP portfolio. And understanding what it is that your prospective licensees or business partners are up to. There we go. Managed to bring it in inside the hour even of the original time. So, so that was a bit of a gallop, but I hope that makes sense. And if you guys have got any questions, and if I don't know, I don't think we're set up for any of the people who are watching this online to ask questions. So if you can channel what their questions might be.
Have you got something?
I don't know. I guess what constitutes a patentable invention? What kinds of things do you need to ensure in your product?
Basically, no. I mean, it's a good question, because I mean, what the system tries to do is be completely agnostic to what the technology is, to the point where if you go to the Australian Patents Act, it says, it's patentable if it's a manner of manufacture within the statute of monopolies of 1587 or whatever that is. So they've tried to effectively let the courts adapt the idea of what's patentable as different technologies develop, because at any one point it's impossible to kind of slap down a statutory definition and say, these are the kinds of technologies that we'll patent. So essentially, as long as it's more than an abstract idea, has some element of a physical effect, and it's novel and inventive, then away you go. So this one I printed off just before I left. So this is a claim that's just been found by the Federal Court of Australia to be patentable subject matter, and it's a bit long, but you'll get the idea if I read through a bit of it. So, a method of gathering evidence relevant to an assessment of an individual's competency relative to a recognised qualification standard. So that's just the preamble. So basically, a method of assessing whether someone meets a qualification standard, including the steps of a computer retrieving via the internet from a remotely located server a plurality of accessible criteria associated with the recognised qualification standard. So, determining what the standards are. Said criteria including one or more elements of competency. Well, each of which is associated with one or more performance criteria. Well, but you can see what someone's doing. They're trying to make it sound as technical and complicated as possible. The computer processing the plurality of accessible criteria to generate automatically the corresponding plurality of questions. So in other words, auto-generating the questions from the competency criteria to satisfy each of the elements of competency associated with the recognised qualification. So they're writing it to make it as long as possible. An assessment server presenting the automatically generated questions via the internet to a computer of an individual requiring assessment, and receiving from the individual via said individual's computer a series of responses to the automatically generated questions. So you see how the game is. Basically, these guys are trying to patent Q&A over the web for the purpose of determining whether someone, meets a qualification standard. And the Federal Court of Australia has just solemnly decided that, not that it was novel and inventive, and that'll be the battleground, but the Patent Office tried to knock it out on the basis of, well, that's just implementing a totally known, obvious, existing process but happening to do it with a computer rather than with a piece of paper and a pen. Anyway, that objection got knocked out. The Federal Court found that, this is potentially patentable. So if you're in the software game, you know, you're just as eligible as anyone else, you know, making chemicals or drugs or whatever, to get a patent for what it is that you do these days.
So I think I heard you say before, is it roughly about 15,000 if you're going to lodge overseas and here as well?
It's
after the provisional.
I mean, realistically, and kind of allowing for the fact that things always blow out a little bit, the timeline is, you know, $5,000 at the start to file a provisional patent application, and there might be another $5,000 worth of advice, or you know, your patent attorneys might do a search or something in the course of that first year. After the first year's over, 10, 15 grand buys you a sort of a multi-country worldwide patent application, and then that sits there for 18 months without a lot happening. There's an international search that's done that you can respond to if you want to. But what it means is for sort of, you know, $25,000 spread over 2.5 years, you've effectively potentially protected what it is that you've got. The trouble is, at the end of the 2.5 years, of course, that's when it gets expensive. You're looking at, you know, 5 or 10 grand per country to, you know, so you'd probably only go into half a dozen countries anyway, maybe 10 tops. But it's still, that's when it gets really expensive. But don't forget, this is 2.5 years down the track, and the speed that a startup, especially an ICT startup, moves at the end of 2.5 years, you're either going to know that it's worth it, or you're going to know that it's not worth it. And then, so it's kind of like, how I describe it to people who think in money terms is, it's like buying an option. You know, the provisional is a $5,000 1-year option. The PCT, the multi-country patent application, is a $15,000 18-month option, and then you exercise the option by going the next step. Makes sense.
Yeah, it makes sense. If you're if you're a startup and to get to the stage where you're able to pay for the PCT 15,000, it's probably likely that you would have disclosed within that period, within that 12-month grace period. So would you be you'd have to kind of be looking at getting investment and asking for a portion solely for that purpose?
No, absolutely. And you know, patent costs are a totally legit sort of expense to expect investors to cover. And it's, you know, if you can make a case that there's potential protection there, it's quite a saleable proposition. I mean, I know it's a lot of money if you're sitting as a student in a startup, but you know, you hopefully wouldn't be doing this if, you know, you didn't kind of believe that whatever it is that you're doing has a net present value of, you know, at least millions of dollars. And if it does have a net present value of at least millions of dollars, then locked out. Then it's worth scraping what you can to try and sort of get that foundational protection for what you're doing. So,
yeah, makes sense.
Makes sense. Yeah. And there are patent attorneys that, you know, will do things cheaper or for fixed fees, or, you know, I mean, I've kind of been at more kind of big end of town practices, but there are smaller practices of younger patent attorneys who, you know, try and make it easy for you at the start, and then if it goes well, they'll hit you at the back end when you start going in every country, and that's fine, because by then you've got the money. Right. All done? Okay, guys. Well, I don't know what we have to do to shut off, but I assume people will just drift away from the.
We'll just yell at James to comment.
That's right.
Yeah.
I'm sure he'll sort it.
All right. Thanks for that.
No worries.
Yeah, it was great.
And James knows where to find me if you've got any questions.
Questions?
Yeah.
It's not necessary, but we had a diligent case. So we just not have that. And then it'll be the copy inside of it. No, because to patent something you have to be the inventor. So yeah, so if you've started to commercially use something, and that as you said is public, then nobody else can come in and use it. I mean, it does happen, and occasionally you'll see it happen. You know, someone will